And my feeling at the moment is that you may not be able to, certainly by reason of the operation of the Land Titles Act, there may be a different result under the Registry Act. Even assuming that you did get a register, however, I guess the question really is what's the effect of contravening a negative pledge? If what you're trying to do is to get a charge on the land for the purpose of realizing on security, the question is when does the crystallization take place under your floating charge, for example? If by the mere registering of your second position, so-called second position mortgage, you did have a fixed charge in it, that automatically crystallized the debenture under your floating charge record. You see what I mean? If you hit someone on the land,
Just for the benefit of the people that are watching it on television, who will be watching it on television, let me repeat what has just been said by Mr. Pierce. He notes that under the Land Titles Act, there may be a problem of registering a floating charge in any event because it may constitute the instrument a fixed charge and therefore be inconsistent with the whole theory of the exercise. And secondly, what is the implications of the negative pledge vis-a-vis a person who is a third party to the contract? Does the floating charge crystallize upon the happening of an event of a default? I think the answer to that is no. I think to crystallize a floating charge, you must take some affirmative steps to appoint a receiver, to move in, to take advantage of the remedies of crystallization. I suppose the remaining question is whether or not equitable principles with respect to restitution would arise where you had indeed actual knowledge of the negative pledge. This is obviously heavy stuff, so we better move on to the next point.
Gordon, can I just for a moment, I said I disagreed this at the beginning. I said a floating charge creates no interest in real property. The question was here earlier about the, does the registration give you, I assume, does the registration of a floating charge create a mortgage on the property? And the answer to that is clearly no. And my question earlier when I was reviewing this whole material, I wrote down on the side here, is the issue here, this paragraph, is the issue here, what do you have? That is, what does this lender have? Or is the issue, where should you register?
Mm-hmm. Well, it's certainly where should you register, and I suppose one of the two places is the CSRA and the PPSA, and then the question arises as to whether or not, if there are significant real properties, whether you register against those properties and what the implications of that registration is. And,
Gordon, it's not appropriate for you, but young people in my firm, I tell them to register.
all right, well, at Opinions Law Society Conference Part 2, organized by Mr. Spence, some future time we'll resolve this issue. After acquired property, the charge, typically a floating charge, is expressed to cover after acquired property. There has been a practice developed in the past of simply stating that fact, and the first 4 lines in Part 2 on page 193 gives an example of that, a simple statement that the floating charge is expressed to cover all the undertaking property and assets of the borrower hereafter acquired by the borrower of whatsoever nature or kind and wheresoever situate. As I say, lately, some lenders' counsel have been asking for a little more affirmative statement. There has developed the practice, I shouldn't dignify it with the word practice. Sometimes the following formulation has been used, as I say, query its usefulness and meaningfulness to the addressee of the opinion. The formulation is, we express no opinion with respect to the validity and enforceability of the mortgage which purports to charge after acquired property, except that in our opinion, upon acquisition by the borrower of any such assets, the debenture will constitute a valid equitable mortgage or charge, as the case may be, of the interests of the borrower in the assets so acquired.
I just think that's a whole lot of nonsense. I really do. the lawyer's saying we express no opinion with respect to the validity and enforceability of the mortgage and charge contained in the debenture. No. We're asking for the lawyer's opinion on what's there and what's good. Do we have a floating charge or not? And then, I think the statement above is the correct statement in an opinion. We get down into all this language at the bottom. I'm not sure what an equitable mortgage is.
Right.
I've spent a lot of time in the library trying to figure it out, never come up with a good answer.
It's a mortgage of an equity of redemption, I guess. Is that what it is?
I don't.
I have a problem with this too, maybe for the same reason, but also from the very nature of a floating charge.
Do you have a floating charge?
It floats, and the whole concept is that it covers turning over property all the time, whatever it might be, and really doesn't become specific until it crystallizes. And what all this mumbo jumbo at the bottom of page 7 means, I don't understand it.
Right. The other problem with that mumbo jumbo is that, of course, when it talks about a equitable charge and there's been registration of the instrument under the PPSA, which provides for a statutory charge, query where you are. I'm afraid we might move out of time, run out of time, so I'm going to move right along. On the first floating charge question, people have been reluctant to give an opinion that that a charge constitutes a first floating charge. If first means anything, I suppose it means that there are no prior encumbrances other than the floating charge created by the instrument or encumbrances which are permitted by the instrument, such as statutory liens and certain other limited purchase money mortgages up to say 66 2/3% of the value of the property. Interestingly enough, lenders' counsel are zeroing in on the same matter from a slightly different perspective, and I won't read the extensive language at the bottom of page 194, but what it says is, look, give me an opinion that you've examined the PPSA registers and the CSRA, and you found out that there's only the floating charge and permitted encumbrances registered against the property, and that in turn, as I say, involves an investigation which requires the obtaining of an officer's certificate, and this is going to really open a can of worms at this panel, an officer's certificate as to what outstanding encumbrances there are, and then an evaluation, and probably an evaluation only by a lawyer. So it's probably appropriate to get this kind of an opinion from the Assistant General Counsel of the corporation, an evaluation that those specific registered charges constitute encumbrances which are indeed permitted by the trust indenture. I guess having done all of that, having examined the registers, having got that kind of certificate which encompasses such evaluation, you may be in a position to assure the lender that there isn't anything ahead of it. Well, these guys really don't believe all of that. Let me short circuit the point. The question about the officer's certificate has been raised on a number of occasions by different panels. It's the old problem about the officer's certificate transgressing the statement of fact and making a conclusion of law.
I think that officer's certificates, if they're drafted in the form of being or including legal conclusions, are no help to a lawyer. That is, the lawyers couldn't rely on that as evidence of the fact that there are no liens. The officer's certificate should speak to factual matters, and to the extent it does deal with factual matters, I think lawyers can rely on it. But to the extent it purports to set forth legal conclusions, I don't think the lawyers can rely on it or accept that.
Yeah. The judgment as to when you move from fact to law can be difficult in a given case. The earlier panel discussed this. For example, I would think a certificate that said there are no unanimous shareholders agreement is a legal opinion. But a certificate that said that there are no agreements other than the following relating to arrangements among shareholders would be a factual certificate in which a lawyer could rely on.
I must say, too, with respect to some of the comments of the earlier panel with respect to bylaws, I'd be interested in your respective views of this, but I think certainly in a financing transaction, one must get a copy of all of the bylaws of the corporation together with a certificate of the secretary that they constitute all of the bylaws in effect on the date of the date of the transaction.
I think there's clearly a duty to inquire.
But even a certificate of the secretary that they constitute all the bylaws of the company in effect on the date of the transaction is a legal opinion in part because it's a judgment as to what's been repealed or amendment or otherwise.
Purdy, having received such a certificate, I wouldn't think you'd be negligent for failing to ask.
Not if you got it from the secretary. He's assumed to know something about the law of amending bylaws, I guess.
But the comment was raised earlier from some in the audience saying, well, what about simply relying on the indoor management rules? And I think in loan transactions that involve reasonable amount of money, a lawyer could not get away with that. Or
the danger of relying on the indoor management rule is such things as your client going out, the officer of the bank, who may be your client, going out afterwards or during the course of the negotiation of the transaction or the day before closing with representative of your client and your client saying, oh, we never enact these resolutions, that's all for the birds. Well, your indoor management rule is dead then, because you're put on notice maybe.
Right. There's one little second paragraph in 195 alludes to a recent case, a 1981 case, which confirms what most of us believed, and that is that the equitable principle of prior in time is prior in right, is indeed, at least so far as the Ontario High Court is concerned, the law of Ontario. This concerned a case where a second floating charge crystallized before the first floating charge, and utilizing the legal principles that seem to be becoming more common in the interpretation of contracts, namely giving effect to the intention of the parties, which Peter alluded to indirectly in connection with the conversion of currency clause. The judge found that the intention of the parties was that the first charge should be a first charge and a rose is a rose is a rose.
Gordon, just an interesting speculation there. Suppose the language of the first, so-called first, that is first in time, the language was such that that charge had not crystallized by the time the second crystallizes. What then?
I don't think that case turned on that point. I think that, I think it turned on intention. There's a reference to enforceability of guarantees, which I think is self-explanatory. There's the question of reliance on local counsel. The only point that's raised there, and it surfaced from the article that, or one of the articles in the bibliography, I don't think it's the one that Purdy referred to, but one of the other ones. The group that was concerned with the formulation of opinions with respect to reliance on local counsel suggested that we do not say to our client that he is entitled, that the opinion is in form and substance satisfactory to us, and we're of the opinion that the client is justified in relying on it, but rather form and scope. The use of the word substance connoted in the mind of that committee examination of the underpinnings of the legal opinion.
I guess, Gordon, if I can just take you back for a minute. I think on the enforcement of guarantees, the illustration given is only one illustration that can relate to it. There may be something to be said, like you have a qualification for creditors' rights, you have a qualification for specific performance. There may be something said to make a qualification if you wanted to, except as to laws of general application, which affect the enforcement of guarantees.
Mm-hmm. That's true.
But when Gordon went quickly past that, the note I had was that I may well give you a bad time about opinions and guarantees sometime, Gordon, because I'm very sensitive. I think there are a lot of problems there, and if your client has guaranteed a loan to my client, I want your opinion that that's a good guarantee. And,
Fair enough. What about the form and scope versus form and substance? Any thought on that?
I didn't understand the distinction, really, and I read
No,
it.
I think there is, to my mind. If you say that the opinion of the lawyer in the other jurisdiction is in substance satisfactory, seems to me you're giving some opinion about the laws of the other jurisdiction.
What I've done in that, Purdy, and I'm sure I've seen it, is in form and content satisfactory. Like, I think the client may well wish to know that you consider that that fellow has said what should be covered in the opinion.
That's where I think the reference to scope is perhaps better, form and scope.
One of the typical opinions that is requested is that the execution, performance, and delivery of the relevant contract does not violate any applicable laws or any contract or agreement to which the company is a party or by which its property is bound, which is the summary of the formulation on page 197. The latter point relating to contracts raises an interesting question. The opinion is usually expressed, it does not violate, or at least the execution will not constitute a violation so far as we are aware of the agreement, of any agreement to which the borrower is a party or by which its property is bound. That raises the question of what is the nature of the inquiry, whether or not it's proper to insist that a lawyer who is special counsel to a borrower on a particular transaction who has not, by definition, hitherto acted for the borrower is in any position to give that. Obviously, the word "so far as we are aware" presupposes reasonable grounds for belief and reasonable investigation. I don't know what everybody thinks about that.
I think it's a problem.
It's a problem.
I would comment that the first part of all that language, which say it doesn't conflict with any or require the consent or approval of the government and so on, seems to me if you've given me an opinion that an agreement's valid, binding, that it presupposes that it doesn't require the consent of any governmental authority to enter into the agreement and so on.
Yes, I think that's true.
Yes, Ed?
At that point of a conflict of contracts, to what extent does it rely on officer's certificate in that regard, or is it appropriate to rely on one?
The question, for the benefit of the people watching this, is to what extent, in connection with the opinion that it doesn't violate contracts, etc., to what extent is it proper to rely upon an officer's certificate as to that point?
Well, again, I think, Ed, it's the same point that was made earlier. If the officer's certificate purports to be factual in that he describes the contracts that exist and annexes them, and the opinion is based upon that certificate and an examination of the contracts that are referred to in the certificate, I think it's all right. But if the officer purports to certify that there are no contracts, you may be getting into a delicate area as to whether he's giving a legal opinion or not.
The other aspect of that, of course, is where you have been acting for the corporation for some time and you're asked for that opinion. Necessarily, as part of your due diligence work, you would want to have examined other prior loan agreements and financing agreements to determine whether or not the necessary tests, particularly maintenance covenants, were met. There's a matter that I alluded to at the beginning, at the outset, which is not dealt with in the paper, but was surfaced in our discussions in preparation for the panel, and that relates to the giving of opinions for securities law purposes that a prospectus is accurate and complete in all material respects. Indeed, on Thursday, I was in the States, and the subject came up of such an opinion, and the conversation went on between two eminent law firms in New York. The first firm was acting for the underwriter and said, I assume that your firm will give the typical prospectus type of opinion. And the response from the issuer's counsel was, of course, we'll have no difficulty in doing so, and we assume that you won't either. And of course, that was a little bit of game playing, because in this particular instance, counsel for the underwriter had not participated as fully by virtue of the underwriter's own decision in the meetings. Just to put some flesh on the bones, that opinion is an opinion. They want an opinion that nothing has come to the attention of the people who participated in the prospectus preparation process, which leads them to believe that the prospectus is untrue or inaccurate in any material respect. And let me just, at the risk of taking a few more minutes, give you some wording that after a fair amount of agonizing and deliberation in our firm, we are now comfortable in giving. Because a lawyer vouching for the accuracy and completeness of the prospectus document is sort of dynamite stuff. The opinion says, and I'm contracting it, while we do not assume responsibility for the accuracy or completeness of the statements in the prospectus, and while we have not performed any independent check or verification of such statements, that's the statements in the prospectus, nothing has come to our attention which leads us to believe that the prospectus at the time it became effective contained any untrue statement of material fact or omitted a statement of material fact. The addressee of the opinion says, look, you're an experienced securities counsel firm, and you were there and throughout this whole process, and we want you to tell us that in the whole process of the development of the prospectus and the cross-examination between the underwriter and the officers of the issuer, nothing surfaced which did not get into the prospectus and which you believe would be material to the investor. So we now give that opinion that way, and I guess we were sort of dragged kicking and screaming into it. As I said, it is a very typical opinion in the United States.
Peter, would you give that opinion?
Yep. I think it's reasonable. I think a person is entitled to know that you're not aware of something your client's hiding.
Gord, can I raise a couple of minor issues?
You bet.
There's a question this morning about, giving your client a simple opinion you're going to win. And it was thought that that wasn't appropriate. There are clients and there are clients. The minions that put away these big books in institutions are one thing, but have a real live client, why shouldn't you give them that opinion if you think you can without doing it in 8 pages, just doing it in 1 line? I have what I call nervous opinions. You have a client who comes in and he's all upset, and he's going to lose 8 nights' sleep over some problem he has. And you know from your experience, one, that if he's sued, he'll probably defend it successfully, but you can't be sure. But you also know from your experience that the odds are of ever getting to court are about 1 in 50. I never have any problem telling that client he has absolutely nothing to worry about and go home and forget about it. Now, what sort of opinion is that?
A gutsy opinion.
No, that's the reassurance, and I think lawyers should reassure clients when they can, and I think lawyers often tend to be too reluctant to do it. Hence, you get all this great, long, elaborate opinions with qualifications. I agree with Purdy.
I want to leave you with one last opinion matter, which I wish we had time to explore.
We have a gentleman who wants to ask a question of his partner. I emphasize it.
No,
The question you were bouncing around just a minute ago about participation of counsel in preparation of prospectus documents, disclosure documents, and finding thereon. On page 226, Emerson suggests that the lawyer shouldn't have finding those things.
Mr. Emerson's going to be talking next. You can ask him.
Mr. Emerson's going to be talking next, and he can deal, Mr. Kerwin, with that and with the matter that I'm about to raise. Since Mr. Beattie and Mr. Crawford set a few minefields going in this panel, why don't we just sort of do a little slop-over work for Mr. Emerson on the next panel? And that relates to the question whether or not when you're doing a share transaction and the opinion is to be given that the shares are fully paid and non-assessable, whether it is adequate to deliver a certified check on closing. Now, I understand that there is some question as to whether or not, since the OBCA says that a mere promise to pay is inadequate consideration, there may be some question if a certified check is delivered on closing, some question as to whether or not you can give the opinion that the shares have been issued as fully paid. Now, Mr. Beattie would probably have a very good...
If this isn't going to be repeated, my reaction to that argument is...
It's only the Law Society. Your reaction is what?
Horseshit.
It's even more complicated than that, though. You may have to look back and see whether the information circular that was used at the meeting which created the shares which you're going to issue was defective, and therefore the shares that you created could be set aside, and therefore you haven't got any shares to issue.
That's right. Well, we'd like to stay around and cause a lot more trouble, but I guess we better go.
Mr. Emerson will answer all questions.
All residual questions.
Ladies and gentlemen, the title for this last session in the materials is Legal Interpretation. I guess on reflection that doesn't really distinguish it much from the rest of the discussion throughout the day. Gar Emerson, who I'll introduce in a moment, is going to speak about securities law interpretation questions. I'm going to talk about FIRA. We don't have any scheduled panel discussion, but I think when we're finished our remarks, we'll constitute this whole meeting a panel discussion, including Peter Beattie. Gar Emerson is a partner in the Toronto law firm of Davies, Ward & Beck. Gar will be well known to many of you. He practices extensively in the field of corporate and securities law. Gar?
Thank you, Jim. Ladies and gentlemen, to begin with, I'll just like to make a general point, and that is that in the securities law context, especially with respect to transactions that are in the public forum, I think that there's basically little difference between professional advice, which is given by a lawyer, either orally or in writing, and similar advice which is embodied in the drafting of documents, including prospectuses, takeover bids, or other public material. Therefore, in speaking of opinions in the context of securities law, basically I think they should include all aspects of rendering professional advice, irrespective of the manner in which the advice is given. I think this morning John Evans said that he's never given an opinion in a takeover bid. I'm not really sure that that's so. I'd like to talk to John about that. I think that professional opinions by lawyers involved in matters are given in every public securities transaction. Very few of the opinions that you give are ever reduced to writing. I'll just give you one quick little quote from the SEC in the Ree Carter disciplinary hearing. Quotes, "We do not distinguish between the professional advice of a lawyer given orally or in writing and similar advice which is embodied in drafting documents to be filed with the Commission. Liability in these circumstances should not turn on such artificial distinctions, particularly in light of the almost limitless range of forms which legal advice might take," unquote. Therefore, I think it's important to remember that in referring to legal opinions, that we're not talking here of the stylized, formal, written opinion that's given at the closing. We're talking here in particular of opinions that are given or advice that is rendered in connection with the organization or structuring of a transaction, and certainly advice that's given in the course of the transaction as it unfolds. The second point that I'd like to make in terms of this area of the law is that I think in rendering advice you must take into account the special policy purposes and objectives of the Securities Acts. The courts of Ontario and the Supreme Court of Canada have on several occasions clearly stated that the purpose of the legislation is to protect the public, and that the statute should be interpreted in light of that policy basis. With this primary objective, the courts and the Supreme Court of Canada have viewed the legislation as remedial and have essentially instructed the courts and the commissions and other regulatory bodies to construe that legislation in a broad way and to look at the economic realities of the transaction, to look at the substance of the transaction and not necessarily only its technical form. This clearly has been the line of interpretation by the Ontario Securities Commission. A number of cases, I refer to the ATCO IU one as by way of example at page 209, 210. A more recent transaction that is similar to that is, for instance, a situation where under the terms of the TSE bylaws, you can only issue 25% of the Treasury shares by way of private placement without a shareholders meeting. A transaction was set up whereby that was done, but concurrently with that, another 15% approximately was issued under employee stock options. The employees then immediately transferred to another buyer the same day. The exchange and the commission both held that in substance that was a private placement, notwithstanding the form of the transaction, and required shareholders' ratification for it. Sometimes this substance of the transaction approach is referred to as the spirit and intent of the act, as to not necessarily criticize things, but in a way to say that it's not a legal, strict legal or proper legal interpretation. But that, I believe, is where that comes from. The position of the Commission is, I think, in many cases clearly stated basically that what they refer to sometimes as, quotes, the sophisticated gloss of technicality, unquote, can't be used to get away from this basic policy purpose. I think this is important in the context that courts, in reviewing matters of the securities context, are basically reluctant to overrule a Securities Commission or regulatory authority's decision in respect to the transaction. If a commission or regulatory approval takes that position, then the courts will be very deferential and will not turn that decision around unless it can be shown, unless the commission can be shown to have acted in clear error of law or fact. I mention the commission and the regulatory authorities obviously because they're so important in connection with the securities transaction itself, because at the current time they're the primary supervisor of the accuracy, if you will, of the legal opinion, and to the extent that the legal opinion is a prediction of how a court or a commission will view the transaction that you're involved in. In Section 2, I've set out some factors which I think might be considered as initial general guidelines that are appropriate for legal opinions in a securities context. Many of them, of course, are relevant for securities for opinions generally. But as we come through this piece, I think that it's particularly important in a couple of areas for a securities lawyer to know, first of all, the purpose of which his opinion is going to be used. And this, as I say, is in connection with advice, but sometimes obviously in connection with written opinions. The scope and nature and who's going to rely on the opinion, as you heard this morning, in terms of reliance and liability is very important, but it's particularly important in finding out perhaps not necessarily who your client is, but who your opinion is ultimately addressed to and who will in fact be relying upon that opinion. And I can just refer you obviously to simple situations, not only of rendering opinions in connection with prospectus transactions, also in connection with exempt transactions, whether or not an investment does or does not require a prospectus, and also to opinions in connection with mergers or amalgamations or takeover bids. In those cases, you know that your opinion is going to be relied on by more people than just your immediate client. Those can be contrasted to situations where you know that your opinion is effectively stopped to the client, i.e. he wants it only for a particular transaction, to know whether, for instance, a particular trade in a security does or does not violate the prospectus or registration requirements of the Act or whatever. But it's very important to know how far that opinion is going to go once you let it leave your desk, because if it takes on a life of its own and is passed along and other people are relying on it, then I think not only does that increase your liability, but it may also increase not only your obligations to those people, but the extent of your due diligence of the facts in connection with which you're rendering that opinion. The second area that I think is very important in here, and it's important in every opinion, and that is to know the facts upon which you're rendering the opinion. Now that's a very simple thing to say, but I think it's important. It's important in all contexts. The trouble in securities matters sometimes is that the determination of the facts is a little more difficult to ascertain. The facts include more than just the objective facts, the facts that people clearly know. They also include what I can refer to perhaps as subjective facts, or facts upon which are dependent in part upon legal analysis, i.e., does a conversation between an issuer and a potential investor constitute a, quote, solicitation, close quotes, for securities law purposes? Does a background set of facts become a fact of a different nature for the purposes of the opinion, for the purposes of the exemption, or whatever? And these are questions of mixed fact and law. In many cases, the client will not know what the facts are, in quotes, or he won't know what the important facts are. And then it's the duty of the lawyer in those cases to ascertain the facts through investigation and inquiry with the client, and to determine what the essential facts are for the purpose of giving the opinion, as opposed to relying upon the client to give you those facts. I've quoted some material at 216 through 219, etc., and I won't go through that here, but it does raise the issue of the extent of the due diligence, a very difficult matter, but an issue which I believe is there, namely that there must be some due diligence. You can't just accept the facts basically without some skepticism and investigation. It may be that all of the relationship with the client and the background and your knowledge will temper the degree of that and make it quite different. And you can see, if you read through these passages, I think how a number of people have attempted to deal with this difficult issue of how far you have to go in verifying the facts. But it's clear that an opinion is no good unless the facts are right, and it's clear that an opinion based upon improper facts can create a great deal of damage and therefore cause problems for the lawyer giving that kind of an opinion. In connection with ascertaining the facts, I think it's important that with respect to reviewing factual matters that can be obtained out of documents or agreements or constating documents or whatever, that be done by the lawyer and not by the client. In other words, with respect to those kinds of matters, I think that the firm should do its own review and not rely on an interpretation of the documents or material from the client. Now, obviously, there may be exceptions to that to the extent that there is a good in-house counsel at the client who you can get some great deal of comfort for, but with respect to material matters, I think you've got to go right to the documents themselves. Now, another issue that comes up in rendering legal advice here is that where your advice in connection with a transaction may be different from a known policy of a commission or a regulatory authority, then I think you should bring that position to the knowledge of your client. In other words, you may, after reviewing the law, feel quite strongly and firmly that your opinion is right. But if you know that the commission or the exchange or whomever takes a different view as a matter of practice or administration of the Act, then I think you owe a duty to your client to bring that to his knowledge. It's similar in a sense to a situation where you're giving an opinion which has not had the benefit of prior judicial review, and it's an opinion on an initial matter, and it's drawing that kind of a situation to your client as well. A couple of those instances come up, for instance, because I know some people, for instance, believe that in the closed system, once you take a private placement, that people, I think it's wrong, but may give an opinion that if you resell the securities outside of Ontario, that that trade is exempt from the resale restrictions. That's an example of what I'm referring to. Or a situation where you're doing a takeover bid or a private agreement outside the province, and the Commission may or may not, in circumstances, consider that the Act applies. Another worry that I have in securities opinions is an opinion that you give based upon hypothetical facts and not a real live blood and gut situation. I think it's very dangerous to give an opinion that, assuming A happens and B happens, then the Act does not apply, or it's exempt from this or that or whatever. Unless you are absolutely clear that that opinion is going to be used in very limited circumstances, won't be relied upon by anyone other than your client, and won't be used as a tool or something that someone may shop around in connection with a transaction, then I think it's very dangerous because of the degree of misunderstanding or misuse such an opinion, in quotes, in the air, close quotes, can have, and because of the obligation that regulatory authorities, and I think courts ultimately, are going to place upon the professionalism of a lawyer involved in that kind of a transaction. In other words, that kind of an opinion, in effect, can be used as a tool for improper purposes, and it comes back to my initial point that you must know where your opinion's going and what it's going to be used for. The next point I'd like to make is this, that if in a transaction a client asks for some specific advice, if the nature of the opinion he requests is not sufficient for his purposes, I think you owe him a duty to broaden the scope and give him advice in other areas. For instance, he may be asking you advice with respect to a private purchase of shares or a takeover bid or something. I think then if you see in the transaction that there may be insider trading problems, you've got to deal with that. Clients may not know all of the issues that are relevant, legal issues as well as factual issues to their case, and I think you've got to bring that to their attention. Similarly, I think you should advise them that if the facts upon which you're giving an opinion are important but fragile, that you've got to make him recognize that his interests may not be adequately protected in getting that opinion if the facts aren't, let's say, firmed up. Let me move on and just make a few comments about the role of the lawyer in the preparation of prospectuses following along the last panel. I've reviewed or set out some initial thoughts in Section 3 on that, starting at page 225. And I guess basically I do feel that in that connection, a lawyer in assisting in the preparation of a prospectus should not act or be required to function as an additional warrantor of the facts that are set out in the prospectus, nor give an opinion, and I'm talking about an opinion, that the prospectus contains all material facts. That, as was referred to earlier, is what I have referred to on page 226. I also, however, refer over on page 233 in paragraph 310 to the kind of opinion that Gordon Coleman was referring to earlier, and I've just made a slip and I'll come back. It's not an opinion. The kind of statement that Gordon Coleman was referring to earlier, that the lawyer involved in the preparation does not have a belief that the prospectus contains a misrepresentation. I think that kind of a statement, which I don't think should be an opinion, is appropriate and can be given if requested, and perhaps it may develop that it should be given in the context. I'm not sure that lawyers effectively aren't doing that now in any event without putting it in writing. I think the duty may go that far, although that's certainly not clear from the cases. But I think there is a difference between warranting the facts and giving the kind of concluding paragraph or separate letter statement that is referred to in 310 and that Gordon was referring to. I've made some comments starting at page 236 about materiality and the difficulty that a securities lawyer has in dealing with that concept. It's a absolutely pivotal concept in connection with most of the transactions that we do in connection with the Act. There will be cases, I think, where a lawyer cannot give an opinion as to materiality. There will be cases where he can, if the facts are clear and you may have some settled law in the area. There will be probably a great deal of cases, maybe even the majority, where it may be impossible to give an opinion as to materiality, but that doesn't mean that you can't be helpful in giving guidance and counseling to the client with respect to those matters. It's a very difficult area, and I've referred to some of the cases in which it's come up and perhaps what a lawyer can or cannot do in coming to those decisions. The problem is, of course, that the determinations of materiality, in large part, in many cases, depend upon factual matters in respect of which I don't think a lawyer can give an opinion, but which are important, obviously, to the rendering of an opinion. To the extent that the materiality is a matter of fact, then I think that may be outside of our scope in rendering professional advice. There's one other aspect, if I have a minute, that I'd like to refer to, and that comes back to where I started from in the sense that the role of the securities lawyer in the public transaction imposes upon him, I think, special liability questions. You had this morning issues concerning Headley Byrne, Hagan, Bamford, and Ross and Conters, cases which I've referred to in 245, 246. Those kinds of cases are clearly applicable where legal opinions are rendered in connection with amalgamations, information circulars, and things of that nature, where public investors beyond your client will be relying upon that opinion in making an investment decision. I think that to the extent the opinion is wrong, the lawyer may be held liable to that class of public investor. In cases where it perhaps is not a written opinion, but a client makes a decision as to disclosure or whatever, and the client is held liable, he may have a claim against the lawyer relating to that oral and perhaps negligent advice. Going beyond that, as I think most of you probably know, the law provides special statutory civil liabilities in connection with opinions relating to prospectuses and to takeover bids, and the defense there, if the opinion is wrong, is of course a due diligence defense. The other area of liability is one that has received more attention in the States and in respect of which there's still no clear answers, and that is the extent to which a securities lawyer may be held liable outside of common law or statutory liability in connection with negligent advice as a result of administrative sanctions or as a result of being held in effect as an aider and abettor of a problem that the client has. The Ontario Securities Commission has attempted to deal with this initially in the Canada Cement Lafarge case, which is referred to at 251 and 252. And there you'll see that the Commission held the lawyers in effect liable for failing to have the company provide proper disclosure. If you read it closely, it's a failure of the company to make disclosure, and the company's failure is the lawyer's failure. And therefore, in effect, it's the lawyer's fault. The procedures, they say, that were the lawyer's procedures and developed by the lawyer were just not adequate. This situation is not too different from the National Student Marketing case, and I just want to remind us that the district court in the United States there held that the lawyers who participated in the closing were aiders and abettors of a violation of the law. And if you remember there, we had a merger based upon financial statements, 9-month financial unaudited, which showed a profit. At closing, the auditors came with an opinion comfort letter, which showed that in their opinion, those 9-month unaudited had to be readjusted. Instead of there being a profit for 9 months, there was a loss. The transaction was closed anyway. The court held that the attorneys were responsible to the shareholders of the company for not preventing that transaction from closing. They should have. They didn't. And the court stated in part that silence in that case was a breach of duty. A breach of duty not to the company, not to the officers, but to the shareholders. And they just quote you one thing. Quotes, contrary to the attorney defendant's contention, imposition of such a duty will not require lawyers to go beyond their accepted role in securities transactions, nor will it compel them to err on the side of conservatism, thereby inhibiting clients' business judgments and candid attorney-client communications. Courts will not lightly overrule an attorney's determination of materiality and the need for disclosure. However, where, as here, the significance of the information clearly removes any doubt concerning the materiality of the information, attorneys cannot rest on asserted business judgments as justification for their failure to make a legal decision pursuant to their fiduciary responsibilities to client shareholders, unquote. That is one court's view of a lawyer's duty in that case. And Jim, I think that's an appropriate place for me to stop at this time. Thank you.
Thank you, Gar.